keep your head up. Don't fall asleep. Don't start doing your hair. Just pay attention to me. If you have to go get your meds because you hear them behind you, step out, get them quickly, but come back. All right. Because I'm not going to sit here and wait. And we're not going to keep calling for you. All right. So if I call somebody and you know they're outside, don't worry about it. Wait till we get to your name and then you can tell them to come in. All right. Let's see what we got here. All right. We got Miss Lena Lewis at ACDC. Okay. That is position 14, Miss Camacho. So we got 22 CP 210316, 347 days without indictment. There is a $123,500 good bond as of March the 20th. Trafficking in methamphetamine, trafficking in cocaine, trafficking in marijuana, BGCSA, possession of controlled substance in Schedule 1 or 2 with intent to distribute, possession of a firearm during the commission of a felony, possession of cocaine, possession of marijuana with intent to distribute, 2 counts of possession of dangerous drugs. Preach! Rah! You're on mute, Bostic.
Okay, let's try that again. 5 prior arrests. First offender for robbery in 2018. Took a hold that has a hold for FTA out of Riverdale. Nothing further.
All right, go ahead, Ms. Camacho.
Yes, good evening, Your Honor. Before you use Ms. Lewis, she is 27 years old. She's lived in Atlanta for the past 15 years. Her entire family also lives here, including her dad, stepmom, her sisters, and her 10-year-old son. She was working to obtain her GED before her arrest and was also working toward cosmetology school. She was also previously working with Atlanta Peach Movers, and my understanding is she can return to that position upon release. Additionally, prior to her arrest, she was attending church with her stepmom and participated in volunteer activities there. If released, she would be able to live with her parents at 934 Garden Walk Boulevard, apartment 1405 in Atlanta, Georgia. She does have some asthma, as well as some mental health concerns, including PTSD and depression. She has enrolled in the New Beginnings program that they offer inside the jail, but her main desire is to be with and care for her 10-year-old son, who misses her and is experiencing some emotional distress as a result of her incarceration. Therefore, Your Honor, we're asking for the total bond amount in this case not to exceed $50,000.
All right, so I know you said Atlanta, but on Garden Walk, some of that's in Clayton County. So is that Fulton County or Clayton County that she lives?
Let me...
Ma'am, is it Fulton? Thumbs up or thumbs down? Thumbs up, okay. All right, what says the state?
Your Honor, this defendant has received a bond as such as her right. The state would ask that you leave the bond as is. If Your Honor is inclined to lower the bond that is currently on for this defendant, we ask that it be no less than $75,000 in total. And the conditions of no drugs without legal prescription, no firearms, ankle monitor is paid for by the county with the 24-hour curfew, with the exceptions of legal, medical, and basic life necessities.
Okay. No drugs unless prescribed, no alcohol, no weapons, no further contact with your co-defendant, Vanlin, V-A-N-L-E-N, last name Preston, P-R-E-S-T-O-N. Stay away from 850 Oak Street in Atlanta, Georgia. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, with the exception of court, medical, attorney visits, and employment, but you have to provide proof of employment, schedule, the exact location you're going to be working. You have to supply that to the ankle monitoring company and to your lawyer. And you can also leave for basic life necessities, but that is a 24-hour curfew unless you're doing some of those things, ma'am. Let's see, and I've already, and by the way, everybody, if it's been over 200 days, I've already sent an email to Ms. Willis saying, hey, what about this case? These people have been in over 200 days and have not been indicted. So let's see, 20,000, 15,000, 10,000, 2,000, 8,000, 3,000, 15,000, 2,000. I'm so yeah, 2,000 and then 1,000. So that's 20,000, 15,000, 10,000, 2,000, 8,000, 3,000, 15,000, 2,000, and 1,000. That ankle monitor will be paid for by the county. Best of luck to you, ma'am.
Thank you, Your Honor.
Okay, let's see. What about, do we have Mr. Dunbar here yet? So we don't have Oconee yet, do we? Let's get. Can we take Marietta Annex or
Judge,
Cobb?
you can do call.
Cobb? All right, Christopher Williams. Wave your hand when I call your name if I call it. All right, Mr.
He was in
Williams.
booth 2.
All right, we got position 21, 22, CP 208556, Christopher Williams, 414 days without indictment. There's a $58,000 good bond as of March the 20th, 2023. Aggravated assault with a deadly weapon, possession of a firearm or knife during the commission of a felony. 414 days. Rah!
8 prior arrests, 2 arrests for probation violation, misdemeanor convictions, time served since in custody on a Schedule 1 substance on 5/26/23. Nothing further.
All right, go ahead.
Yes, Your Honor, before you is Mr. Williams. He is 41 years old. He is born and raised here in Atlanta. And he has his whole family here. That includes his daughter, as well as his mother, who is very sick right now, and Mr. Williams is anxious to get to her. He does have a good address on file. It is the Stapler Court Southwest address, where he would be able to stay with family. He does have his GED, and prior to being arrested, he was working at P&G Propaganda, which is a warehouse where he was stacking pallets. He had been in that employment for almost a year, and it's my understanding that he could potentially get that job back once released from custody. As Your Honor mentioned, Mr. Williams has been in custody for 414 days on this case. At our last bond hearing in March, the state announced that they had not had any contact with the alleged victim in this case. We had a preliminary hearing in this case as well, where it came out at the preliminary hearing where there was no contact with the victim. There was no contact with the alleged witness. There was no surveillance footage at this scene that potentially put Mr. Williams at the scene. This case has not been indicted because there's not much of a case. And it's been 414 days that Mr. Williams has been sitting in custody waiting for something to happen. He currently has a bond that is $58,000, and it is just something that Mr. Williams cannot afford. Again, 414 days. I would ask Your Honor for his bond to be reduced significantly. I am looking into getting him assistance through either the bail project or the Freedom Day bailout, because he will need assistance in posting whatever bond is set by Your Honor this evening. I would ask, there are 2 counts, and I would ask for a bond not to exceed $10,000. We would obviously consent to the conditions that were set by Your Honor back in March, and just reiterate that it has been over 400 days with no movement, and Mr. Williams has been languishing, waiting for something to happen.
And that address is a Fulton County address?
I believe so, Your Honor, but I would have to double check.
Is that a Fulton County address? Give me a thumbs up or a thumbs up. All right, got it. He gave me a thumbs up. What says the state?
Your Honor, this defendant has received a bond at this time, which is his right. The state would ask that you not reduce the bond, being that, again, we are talking about some very serious charges here. If Your Honor is inclined to lower the bond against the state's recommendation, we ask that it be no less than $40,000 with the same conditions already placed on this defendant.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 1447 Campbellton Road in Atlanta, Georgia. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. No further contact with Travis Adams. 414 days, no indictment. We got 20,000 count 1, 5,000 count 2. Best of luck to you, sir. And I did email them that to Miss Willis. What about Xavier Gilliam? Boom. All right. Position number 1. I don't know if it may be one of the add-ons, but anyway, Xavier Gilliam, 23, CP 216485, 110 days without indictment. There's a $20,500 good bond as of February the 24th. Owning an auto or a motor vehicle with intent to commit a theft or a felony, possession of marijuana less than an ounce.
I'm here. I'm just trying to find which number one.
Sure have missed you, Bostic.
This should be position 1 on the.
There's 4 number ones.
I think this is on one of the add-on calendars.
It's the second add-on, so add-on 2.
There's 4 number ones. I don't know which is second add-on. I just got to find it. Xavier Gillum.
That's it.
There's only prior arrest was an aggravated assault 23 SC, and that was no pros, nothing further.
All right, go ahead.
Before you is Mr. Gilliam. He is 20 years old and has lived in Georgia for the past 8 years. He does have family here in the area, including his mother and sister. He does have a good address on file. It is the Shuri Trail address, which is in Fulton County. Mr. Gilliam made it to the 10th grade, and prior to being arrested, he was working at DHL as a package handler. It is my understanding that he is able to and will plan on returning to that employment. As mentioned by pretrial, he has only one prior arrest that was no prost. His current bond is set at $20,500, and he has been in custody for 110 days. Due to the minimal history and the case being dismissed, as well as the time that he has been in custody, I would ask for his bond to be reduced. I would ask for $5,000 on the entering automobile and $1,000 on the marijuana less than 1 ounce.
And he is going to live in Fulton.
Yes, Your Honor.
All right. What says the state? Still on mute, Miss Patton. You're on mute, Miss Patton. You're on mute. Can't hear you. You can wave. Can't hear you.
Can you not hear me?
Now I hear you now.
Okay, thank you, Your Honor. The state would ask that you leave the bond the same. A defendant has been granted a bond and such as his right. If Your Honor is inclined to lower the bond above the state's objection, we ask that it be no less than $15,000 with the same conditions put into place.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 4855 Old National Highway. No further contact with Andre Dudley, Dudley, and no further contact with Ola Dayo, last name OsinUga. All right, I think I already said no drugs, no alcohol, no weapons. So 10,000 count 1, UJR to the jail for the count 2. Best of luck to you, sir. Leave the booth. You can leave the booth. You can leave the booth. Mr. Gilliam, you can leave the booth. What'd you say, Miss Jamie?
Just for clarity, ankle monitor.
Nah, because it had that much fun.
Okay, no ankle monitor. Gotcha.
Right.
Thank you.
Okay. All right, now we got Oconee here. So McKinney Dunbar. All right. This is another number 1, Bostic. It's a 23 CP 216764, 100 days without indictment. There is a $2,500 split bond with no bond being MDMA with intent to distribute. 100 days without indictment. Yeah, 23 CP 216764. Driving on the wrong side of the road, failure to have license on person, possession of open alcohol container, driving with suspended or revoked license, possession of MDMA with intent to distribute, possession of marijuana less than an ounce. And it said 34 grams of suspected MDMA.
Extensive arrest history, 41 prior arrests, 4 misdemeanor, at least 4 felonies, 1 arrest for probation violation, 8 for probation violations, 1 FTA. 2016, Schedule 1 firearm during open case 22 CP 214179 firearm by firearm during cocaine with intent, meth with the intent, purchase, manufacture, and sale of marijuana, Schedule 1 or 2 with the intent to distribute and misrepresent and tag. Nothing further.
All right. Go ahead, Ms. Camacho.
Your Honor, before you is Mr. Dunbar. He is 45 years old and is a lifelong resident of Atlanta. His family does live here, including his mom and his brother and his 16-year-old daughter. Mr. Dunbar has completed the 10th grade, and prior to his arrest, he was working in home renovation, which he believes he would be able to return to. He's also a member of a church and has often volunteered with that church. If released, Mr. Dunbar could reside at 1004 Beckwith Street, Atlanta, Georgia, with his mom. Mr. Dunbar was involved in a car accident in the past and sustained severe back injuries, for which he often goes to the chiropractor for treatment for, but has been unable to get chiropractic treatment since being incarcerated. Given these considerations, we ask your honor to set bond not to exceed $10,000.
All right, what says the state?
Yes, Your Honor, this defendant has been given a bond as such as his right. The state would ask that you do not lower the bond. However, if you are inclined that the bond be no less than $12,500.
All right, let's see. Count one, 500, 500. 3, UJR jail. 500, count 4. 15,000, count 5. UJR jail, count 6. No drugs unless prescribed, no alcohol, no weapons. No driving until you have valid license, insurance, and registration. Also, you're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, and basic life necessities. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. And you need to supply that to the ankle monitoring company and to your attorney. And gentlemen and ladies, by the way, the state actually gets a report of where you go with the ankle monitor. So don't try to outsmart the ankle monitor. Best of luck to you, sir. You can leave the booth. Thank you, Oconee. All right, we got Larry Marshall. Wave your hand if correct. Larry Marshall. No, hold on a second.
Larry of the annex.
Where's Larry Marshall? Oh, that's ACDC. Stand by. Let's see. All right, let's see. Jared Grissom. This another number one. Bostic 22 CP 213267. Jared Grissom. 238 days without indictment. There's a $5,000 good bond as of January the 19th, 2023 on theft by shoplifting. Free trial. Now you're talking, Bostic, but you're muted.
Oh, I was singing to myself.
Oh,
There it
thank
is.
God you were muted.
21 prior arrests, 4 misdemeanors, 2 arrests for probation violations. 20 SC 176730, open theft by shoplifting, 2 arrests for probation violations. First offender, theft by shoplifting out of the cab. 3/9/20, 15 months confinement, 3 years, 9 months probation. And also then there's a theft by shoplifting, 5 counts. Sentence same day, nothing further.
All right. Just Miss Rondon.
Your Honor, I think I missed this add-on calendar. Can we come back to Mr. Grisham, please?
Okay, swap seats, Mr. Grissom. Real quick. Do you need that booking number or?
I looked it up while we were talking.
Okay. All right. So we'll go ahead with Edwin Ryan. 23, it's number 19, 23 CP 215522, 147 days without indictment, purchase, possession, manufacture, distribution of marijuana, possession of firearm during the commission of or attempt to commit certain felonies, possession of firearm by a convicted felon, improper left turn. There is a $600 split bond with $600 on the improper left turn. The other ones are no bond as of January the 18th, 2023, 147 days without indictment, 39 alleged grams of weed. Free trial.
Multi-state offender, California. And 4 in Georgia, FBI hold 20 in California, couple of misdemeanors. Open cases, 21 SC 178442, firearm by misdemeanor possession, 21 SC 178652, schedule 1, firearm by. Nothing further.
All right. Already like this. All right.
Great afternoon, Judge. How you doing?
Good. Long time no see. Go ahead.
Your Honor, basically, Mr. Ryan is 28 years old. He does have 3 kids, ages 11, 12, and 6. Prior to being arrested, he was working 3 jobs, dishwashing, Bar Mac, which is a restaurant. He helped service there, and then he did security. 12th grade graduation. If he was able to get out, he would live with his girlfriend and his children. They live in Conyers. We do not have that address right now, but we can get it for you. I spoke to his wife as well as him, and the only thing they can actually make is 10,000. She works a job, but she has to, use all her funds to support the kids and the household while he's currently in custody.
All right, what says the state?
Yes, Your Honor, this defendant is entitled to a bond, and Officer Bostic, correct me if I'm wrong, you said he had a FBI hold?
No,
Oh, I heard you say FBI hold too,
That's
but
what I heard.
I said about FBI, but I didn't say hold.
what did you say about FBI, Bucket?
It's FBI.
All right, go ahead, Ms. Patton.
Okay. For the purchase, possession, manufacture, distribution, or sale of marijuana, state would be recommending 5,000. For the possession of firearm or knife during conviction, state would be recommending 7,500. For the possession of firearm by convicted felon, state would be recommending 10,000. He already has 600 on the improper left turn, so we would ask that remain the same. If no drugs without legal prescription and no firearms while out on bond.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 110th Street Northwest. Stay out of Fulton County. Unless you're for court or to see your lawyer. No reason to come to Fulton County at all. When you come to Fulton County for court or to see your lawyer, fill up with gas where you live. Don't stop for gas. Don't stop for anything to eat. Straight to court, see your lawyer, go to court, and go back home. And run that ankle monitor paid for by the county. 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, exact location you'll be working, and also basic life necessities. 5,000, 7,500, 7,500, and improper left turn, UJR through the jail. Best of luck to you, sir.
Judge, could you repeat those real fast for me, please?
Repeat who?
Repeat the bond amounts for me.
5,000, 7,500, 7,500, and UJR through the jail.
Thank you.
All right. Thank you. Have a good evening. All right. Are you ready, Miss Rondon, or no?
Yes, we can come back.
All right, Mr. Grissom, 22 CP 213267. 238 days of that indictment, $5,000 good bond, felony theft by shoplifting. Do you need to hear his history again?
No, I think I heard it.
Okay, go ahead, Miss Rhonda.
All right, Mr. Grisham is 27 years old. He is from Atlanta. He does have family here, to include his mother, but he is currently residentially challenged. He is a high school graduate. He graduated in 2016. Prior to being incarcerated, he was working at a lawn service. It's my understanding his brother is the one that owns this lawn service and that he would be able to return to that employment once released. He does currently have a $5,000 bond, but it is beyond his means to be able to post. Since he has been in for 238 days, I would ask for his bond to be reduced and cut in half. So that bond is $2,500.
No,
All right. 7 North, booth 3. Get your head up. 7 North, booth 3. Sit up. Sit up. There you go. Go ahead. What says the state?
no objection.
All right. So it'll be a $2,500 good bond. No drugs unless prescribed, no alcohol, no weapons. Stay away from all Home Depot stores, sir. You cannot go to any Home Depot stores, and even the one at 2525 Piedmont Road. No Home Depot stores. $2,500. Best of luck to you, sir. You can leave the booth. Thank you, Marietta Annex. Let's see. We don't have, oh, there's ACDC. What about Larry Marshall? It's another number one, Bostic. 23 CP 217063, 87 days without indictment. There's a $5,000 good bond as of March the 20th on aggravated stalking. Also, number 8, 23 CP 217064, Larry Marshall, 87 days without indictment, as no bond as of March the 20th. Aggravated assault, battery, family violence, battery, family violence. Breach, row. Still muted, Bostic.
8 prior arrests, no prior convictions, other cases dismissed. Another open case, 23 SC 185915, criminal damage to property. Nothing.
All right. Go ahead. I think, no,
Kent Bias for Larry Marshall. Your Honor, Larry Marshall is a 32-year-old young man who was born in Alabama, but moved to Atlanta to attend Morehouse College on a full scholarship. And he's lived here since 2008. He worked at SunTrust Bank for a while, was a school teacher, a pharmacy technician, and then he went to John Marshall Law School and completed that and has been working in legal discovery area. He had multiple jobs when he was arrested, working in legal discovery, and also he is an organist and an accomplished pianist, and he's been performing at church services on Sunday. As you heard, he has no prior convictions and he poses no significant threat. He will have some residence problems. He has an aunt who lives in Lawrenceville that he might be able to live with, but she is in Alabama right now because her mother has had a stroke. My client also has an aunt who lives in Montgomery, Alabama that he could stay with if permitted by the court. We would ask for a $10,000 bond in total. As you said, there was a $5,000 on the aggravated stalking, so we'd ask for another $5,000 on the aggravated assault.
all right, so I just looks like there was an indictment returned on the ag stalking. You want that SC number?
Yes, please.
All right, it's 23 SC 188005. So we're not going to touch that one. And let's see. Let me see if I can see who it's assigned to. Let's see. That's assigned to Judge Schwall. So we don't even have to address that one, Madam Prosecutor, but go ahead with your argument.
Yes, Your Honor. Good afternoon. ADA Washington on behalf of the state. In regards to Larry Marshall, he is a threat to the victim and also a threat to commit future felonies and a danger to persons and property in the community. The victim in this case, Miss Danielle Bragg, I'm not sure she's on the Zoom. I know that she did want to make a stay. Okay, perfect. I'll give you the floor, Miss Bragg. Give me 1 second. But he is a threat to Ms. Bragg, who is on the Zoom and does want to address the court. She has made it known to our office that she is fearful of the defendant and wants no contact with him. She does currently have a TPO against him.
I heard that TPO.
Yes, yes. So she has a TPO against him.
That's a permanent TPO.
And he got the aggravated stalking because he entered through her window. And that was in March, I believe of March 18th of this year. And he came through her window. So while he's out on bond for the criminal damage to property, the 23 SC 185915 case, he's also committing these 2 new offenses against the same victim. So the state made the argument that he's A, not entitled to bond, B, a threat to this victim, and also a threat to commit future felonies pending indictment and pending trial. I'll let Ms. Bragg go ahead and address the court if that's fine with you.
Okay. Ms. Bragg, you need to take yourself off mute, raise your right hand. Do you swear a firm testimony you're about to give is the truth, whole truth, nothing but the truth?
I do.
Okay, go ahead. What would you like to say?
Can you still hear me? My Zoom is frozen.
I can.
Okay. So I believe that Mr. Marshall should not be granted a bond because if he is released, I believe that he will not come back to court because in the past he has dodged law enforcement. I believe that he will continue to physically harm me, making him a threat to me and the community. I believe that he will try to contact me, which would be aggravated stalking, which is a felony since I do have that permanent TPO against him. And I believe that he will continue to harass and intimidate me. And then the original crime has impacted me in many ways. I still have visible marks on my arms, legs, back, and butt from the physical abuse. I have a lot of anxiety and fear of Mr. Marshall returning, and I struggle to fall and stay asleep. He befriended all of my neighbors and they continued to talk to him after I had him removed from my home. So I don't trust my neighbors. I live alone and I own my house with the help of I live alone and I own my house with the help of the Georgia Dream Homeowners Program. So I can't easily or quickly move. I worked from home during the abuse, and Mr. Marshall caused me to miss a lot of days of work. I eventually lost my job, and I'm still trying to recover financially after also having to stay in hotels because I had to leave my home to get away from him. I had to change my locks, and then I've had to pay for other expenses. And so I'm just now making strides to get my life back together from the harm that Mr. Marshall inflicted on me. And that can only continue if my safety is ensured by him having no bond. Thank you.
All right. And counsel, you said he doesn't have an address where he's going to live yet, right?
That's correct.
All right. One of the bond conditions, sir, you're going to have to supply an address where you're going to be living before they let you out. No drugs unless prescribed, no alcohol, no weapons, no further contact with Danielle Bragg. Stay away from 1682 Abner Court Northwest in Atlanta, Georgia. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment. As long as you supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. Ms. Bragg, he's been in jail 87 days without indictment. So on the 90th day, he's entitled to a bond. So what I'm going to do is put a bond on here, but it's not going to go in effect until that 91st day. So if he's indicted by that 90th day, then it'll stay in no bond status. But if he's not indicted, this bond order will go into effect because he's statutorily eligible for a bond after 90 days. Okay.
Okay.
All right. And I think I said no drugs, no alcohol, no weapons. Like I said, sir, you're going to have to provide an address where you're going to be living. You have to provide that before they let you out. I got 25,000 on the ag assault, 15 and 15, 25, 15 and 15. Best of luck to you, sir. That will go into effect. Let's see. So Miss Jamie, I forget what they figured out on how they're going to hold it, but it's A7.
Can I say something? Excuse me, Your Honor, I have an address.
Where is it?
Yeah, I can't live in Lawrenceville and Gwinnett County with my aunt.
Good. Stay out of Fulton County unless you're here for court or to see your lawyer. You need to supply your lawyer with that address so that he can file it with the court. But the only reason you come to Fulton County is court or to see your lawyer. No other reason. No gas, no snacks, no gas station, no nothing. 25,000, 15,000, 15,000.
Judge, what about the add-on?
No, that one's indicted.
Okay, this one's indicted.
That one's indicted, and that one's assigned to Judge Schwall. Best of luck to you, sir.
Thank you.
All right, Derek Bradfield. Thank you, Miss Bragg.
Thank you.
All right, this is position 5, 23, CP 215428, 151 days without indictment. No bond as of 3/6. Possession of controlled substance in Schedule 1 or 2 with intent to distribute. Possession of a firearm or knife during the commission of or attempt to commit certain felonies. Possession of a firearm by a convicted felon. Possession of marijuana less than an ounce. And it's alleged 7.8 grams of crack. Pre-trial.
Extensive criminal history, 48 prior arrests, at least 10 felony convictions, 3 misdemeanors, 2 FTAs, 4 arrests for probation violations, 2 for parole violations. Currently on probation, 18 SC 156602, sentence 32620, 6 years for cocaine. Nothing further.
Go ahead, Ms. Camacho.
Your Honor, before you is Mr. Bradfield. He is 42 years old and is a lifelong resident of Atlanta. His whole family does live in Atlanta, including his 2 young children and his disabled sister. Mr. Bradfield successfully obtained his GED, was working at a temp service in Lithia Springs prior to his arrest, which I understand he could return to upon release. Mr. Bradfield does have a good address at 4605 Santa Fe Trail, Atlanta, Georgia, where he could live with his aunt. Mr. Bradfield's main concern is being able to care for and be with his disabled sister. He has expressed financial difficulty, so we do plan to get him assistance through the bail project.
1 second, Ms. Camacho. 2 North, booth 2. Unless you're getting meds, have a seat. Unless you're getting meds, have a seat. This isn't visitation time with all your friends. Have a seat. Stay in your seat. Unless you are getting meds, stay in your seat. I apologize. Go ahead, Ms. Camacho.
No problem. As I said, Mr. Bradfield has expressed financial difficulty, so we do plan to get assistance for him through the bail project. Therefore, we are asking for bond not to exceed $10,000 to be able to get assistance from the bail project for him.
4 South, booth 3. Turn around and face the camera. Don't lay against the wall. Everybody sit up, just like you're in my courtroom. That's where you're at. What says the state?
Yes, Your Honor, this defendant is entitled to a bond as is right. It's been over 90 days. So that being said, because of this defendant's extensive criminal history, there is a significant likelihood to reoffend. For the VGCSA, possession of controlled substance in Schedule 1 or 2 with intent to distribute, state is recommending $5,000. For the possession of a firearm or knife during commission or attempt to commit certain felonies, state is recommending 7,500. For the possession of a firearm by convicted felon, state is recommending 12,500. And for the possession of marijuana less than 1 ounce, state is recommending a UJR through the jail. No drug without legal prescription, no firearms while out on bond.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 641 Peachtree Street. Stay away from all MARTA property. That also includes bus stops. Sir, if you're walking down the street and your shoe comes untied, you cannot sit down at a bus stop and tie your shoe. You will have to walk past that and sit on the curb. If you sit at that bus stop on that bench, that's a violation of your bond condition. MARTA has also let you know that you've been suspended from MARTA. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, place of employment, schedule, and the exact location you're going to be working. 5,000 count 1, 7,500 count 2. 15,000 count 3, UJR through the jail count 4. Best of luck to you, sir. 5,000, 7,500, 15,000, UJR through the jail. Marlon Royster. All right, this is position 4, Bostic. 23 CP 216939. 91 days without indictment. Criminal damage property, simple battery. No bond as of March the 15th. Free trial.
20 prior arrests, at least 4 felonies and 1 misdemeanor, 1 open misdemeanor for terroristic threats, 21 CR 0026884A. Took a first offender on a felony CWAC TT, aggravated assault firearm during, firearm by an 04, 01, unlawful eavesdropping, 08, armed robbery, 2 counts aggravated assault with intent to rob, 2 counts firearm during, still on probation, sentence 7/13/19, a 15-year sentence, nothing further.
Go ahead, Ms. Rhonda.
Yes, before you is Mr. Royster. He is 40 years old and has lived his entire life in the Atlanta area. He does have his entire family here, including his mother, 12 siblings, and 4 children, ranging in ages from 2 to 24. He does have a good address on file, which is the Absinthe Drive address in Atlanta, where he would be able to live with his fiance and daughter, or wife, I'm sorry, and daughter. I did speak with Miss Lowe, who is the alleged victim in this case, and I think she may be online this evening to speak.
Yolanda Lowe.
Okay, not hearing her pipe up. She did let me know that she sent a letter to the DA's office expressing her intent not to go forward with these charges, as well as saying that, you know, she is not afraid of Mr. Royster and that she wants Mr. Royster to come home. Mr. Royster, prior to being in custody, he was working. He was employed at Home Depot. He had had that job for 4 years, and it's my understanding the manager at that Home Depot location is holding his job for him. So he'll be able to return once he is released from custody. Because Miss Lowe has expressed, her desire for him to come home, as well as that today is the 91st day. So Mr. Royster is entitled to bond. I would be asking for $5,000 on the criminal damage and $1,000 on the simple battery.
All right. And that's the incident location, and the victim, that's his fiance or wife?
Yes, Your Honor.
Okay. What says the state?
No objection to the bond amounts. I will add, though, I have not received any such letter from Ms. Lowe. As such, I would be asking that no contact be put into place. However, it'll be up to the court's discretion as usual as to whether or not to implement that. But I have not been made aware of any letter stating anything otherwise.
And Ms. Rondon, I'm sorry, can you give me those numbers again? I was writing down other notes.
That's okay. I said $5,000 on the criminal damage and $1,000 on the simple battery.
All right. 5,000 on count 1, 1,000 on count 2. No drugs unless prescribed, no alcohol, no weapons. Till we hear something from them, sir, you're going to have to stay away from 7629 Absinthe Drive in South Fulton. And I do this because actually in the warrant, it says that you had 2 guns in your possession and pointed them towards her. No further contact with Yolanda Lowe, L-O-W-E. You can have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. Also, basic life necessities. You're gonna have to supply an address other than the absent drive where you're gonna be living before they'll let you out. Best of luck to you, sir. You can leave the booth. Thank you, Milton. I think that's it. Reuben Gordon. Reuben Gordon. Thumbs up. There you go. All right. 15, Bostic, 21, CP 203537. 607 days without indictment. Burglary in the second degree. $7,500 good bond as of October the 15th, 2021. Pre-trial.
4 prior arrests, device by fraud, 2014, and 1 arrest for probation violation. Nothing further.
All right. Go ahead, Mr. Davis.
Good afternoon. Good evening, Judge. Again, we're here on the case of Reuben Gordon. As the court has pointed out, Mr. Gordon's been in jail now almost 600 days. He's 48 years of age. From what I understand, there is 1 prior felony conviction. Prior to this particular incident, he was working in the food service industry, living at 1118 Joseph E. Boone Drive, Boulevard, excuse me. He does believe that if released, he'd be able to go back to that particular location to reside. Judge, this is a case whereby there are 3 co-defendants on the case. One of the co-defendants actually has about 9 open cases involving burglary or theft by receiving, either or. And we do believe that that may be one of the issues in the delay in this particular indictment. So we would ask the court to give a significantly low bond in this particular case. I'd ask for $1,000 bond. I'm not sure that's typical for Your Honor to do, but in this particular case, I do believe it is warranted. This is a case where we had a full-blown preliminary hearing. The evidence against Mr. Gordon is, I would say, slim at best. So we would ask that the court give a significantly lower bond. His family resides in South Carolina as well as Augusta, Georgia. At this particular time, they're just not in a position to assist him in making even the $7,500 bond. So I just would ask that the court consider setting $1,000 bond in this particular case. We believe that based on the amount of time he's been in custody, as well as the fact that there's been just I would say an unreasonable delay in indictment, we believe that would be a fair amount.
Yeah, he's been
That'd be all, Judge.
607 days without indictment, and he's going to live in Fulton County.
Yes, Your Honor.
Okay. What says the state?
Your Honor, the state would refer to the court's discretion.
Of course. All right. No drugs unless prescribed. No alcohol. No weapons. Stay away from 578 Whitehall Street in Atlanta, Georgia. No further contact with your co-defendants, Naomi Davila, Davilla, and DeJounte Hoosier, DE accent Juante Hoosier, Hoosier. I think I already said no drugs, no alcohol, no weapons. No further contact with Courtney Stewart. Let's see. I'll do all right, we'll have an ankle monitor paid for by the county, 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. I'll do that, and I'll make it a $1,000 good bond. Best of luck to you, sir. You can leave the booth.
Thank you, Judge. That's all I have. May I be excused?
Yes, sir. Have a good evening.
Thank you. You too.
James Solomon. Thank you, sir. Position 9, Bostic, 23, CP 216514. James Solomon, 109 days without indictment, $10,000 good bond as of 2/25/23. 109 days without indictment. Burglary in the second degree, possession of controlled substance, Schedule 2, and willful obstruction misdemeanor. Pre-trial.
Extensive criminal history, repeat offender, 27 prior arrests, 8 felonies going back to the 80s. Most recently, I think, is a cocaine and prior act assault, 4 arrests for probation violation, 1 misdemeanor. Nothing further.
All right, go ahead, Ms. Rondon.
Before you is Mr. Solomon. He is age 62 and has lived in the Atlanta area his entire life. He does have his family here, including his brother and his 9-year-old daughter. He does have a good address. That is the Sylvan Road address where he would live with his brother. He is a high school graduate, graduating in 1999. Prior to being in custody, he was working at Belma Smith Auto Salvage. He has been in custody for 109 days, and his bond is currently set at $10,000. I would ask for the court to cut his bond in half, and have bond not exceed 5,000. I imagine we are going to have to apply to the bail project on Mr. Solomon's behalf and ask for the bail project to come on and provide assistance to Mr. Solomon in paying whatever bond is set by your honor tonight. And so I would ask for that bond not to exceed $5,000.
All right, go ahead, Ms. Patton.
Yes, Your Honor, this defendant has received a bond. As such, we believe the bond put in place is fair and reasonable and would ask the court not to lower it. If Your Honor is inclined to lower the bond against the state's objection, above the state's objection rather, we ask that it be no less than 8,000 in total with the stay away from the incident location and no drugs without legal prescription.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 929 White Street. No further contact with Corey Clark. Gonna have an ankle monitor paid for by the county with that 24-hour curfew. Court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment, schedule, and the exact location you're going to be working. Looks like there was an alleged co-defendant here. Do we have the name of a co-defendant? Is that?
I can pull it up in 1 second, Your Honor.
It just says both males.
The co-defendant's name is Marvin Pace.
Thank
Marvin,
you.
common spelling, Pace, P-A-C-E.
No further contact with your co-defendant, Marvin Pace. 4,500 and 500. Best of luck to you, sir. 4,500, 500. You can leave the booth. Well, is it McHugh Dim? M-A-K-I. Oh, all right, gotcha. This is number 2 on one of these cases, Bostic. This is 22 CP 210160, 354 days without indictment. As of March the 2nd, there's a $245,000 good bond for aggravated assault, armed robbery, possession of a non-firearm during the commission of or attempt to commit certain felonies, ×2. Unlawful for a person to be employed by, associated with criminal street gang, or participate in criminal street gang activity. Preach.
Multi-state offender, arrest in Florida, 7 in Georgia. On probation, 20 SC 174762 for robbery, sentence 5/26/21, 10 months confinement, 4 years, 2 months probation. Also open case 22 SC 185519, signed Judge Edwards, aggravated assault with a deadly weapon ×2, terrorist threats, firearm by, battery and firearm during. Nothing further.
Go ahead, Ms. Rondon.
I'm sorry, Your Honor.
Hold on, go slow. Goodbye. You're driving. We don't drive in YouTube and Zoom. Bye. Bye. Stay safe. Go ahead, Ms. Rondon.
I'm sorry. I apologize. What position are we on?
Number 2, Mr. Dim.
Mr. Dem?
D-E-M.
Is this potentially the add-on calendar that I missed? Can we come back to this, please?
Different add-on.
Oh, you want the different add-ons? Do you want the booking number, or do you see it?
Yes, please. Can I have that?
Go ahead. 22 CP 210160. We're going to give Miss Rhonda a little grace for the next month. She's going to be the entire conflict defender's office.
Oh, I get it.
Okay, we'll
I've
come
been
back
there.
that real
Thank
quick.
you. I appreciate it.
Rashad Waring. All right, we'll come back to you, Mr. Dim. This is position 20, Bostic. 23 CP 216180, 271 days without indictment. Aggravated assault, riot in a penal institution. No bond as of February the 13th.
Multi-state, Virginia. Open cases 22 CP 212376, aggravated assault with a deadly weapon, firearm during. 20 SC 173989, firearm by, misdemeanor possession and judicial hold. In Virginia, 3 felonies, credit card fraud, and 1 conspiracy to distribute cocaine in 2016, and a probation violation. Nothing further.
All right, go ahead.
Great evening, Your Honor. My client, Mr. Waring, we came before you on the other matter. He's 42 years old, 4 kids. The 6-year-old unfortunately does have autism that the family's dealing with, Your Honor. 2 19-year-olds, Your Honor, and a 20-month-old. Prior to this, Your Honor, he's a programmer. He does blockchain developer, and he does work for his own self with IT. He's been in for a little while now. As we know, no violent crimes, no weapons possession that I remember or know of. He would stay in Riverdale with his mother. That address will be 7649 Briarview Court, and that's in Riverdale, Georgia. He is educated. He has 2 degrees, one in business management, the other one in paralegal studies. And he is also in filming school. He was in filming school prior to being arrested, and that's in Georgia by Grant Park. The other case he had was a $50,000 bond. It was lowered to $25,000. I spoke to him on this matter. The family was struggling to get that money on that case. I believe this is the only case that's been holding him in. There's some contradictory when we got facts pertaining to this case here. And I believe it's something that's going to be worked out. I know there was a whole bunch of co-defendants. A lot of them were dismissed or lowered to misdemeanors. So we're here before you asking for a low bond. I would ask for OR bond on this, Sean, to be honest with you. But I would ask for no more than $5,000, just so he can be able to make the bond. His family's working on it. As I said, they took a little while to get the other case. So this is the only thing that's holding him there.
All right, what says the state? Everybody head up. Stay up, stay awake. We're getting through it as quick as we can. Go ahead, Ms. Patton.
Yes, Your Honor. I do believe, does this defendant have a bond on these charges? I didn't hear you at first.
There's no bond on this one.
Okay, so he definitely is entitled for a bond as it's been over 90 days. However, based upon the nature of these charges, if you look at the 4 corners of the warrant, particularly the riot in a penal institution, what's alleged here is use of a weapon, which would serve as a danger to the victim and to the community. The state would ask that for the aggravated assault, bond be set no less than $25,000. For the riot in a penal institution, bond be set no less than $20,000 on that one. Conditions of no weapons, whether man-made or otherwise, and no contact as much as possible. I know they don't control where they go in the jail, but as much as possible with the co-defendants in this case and the victim in this case.
All right,
They all share a pod, Your Honor. So I know that's, you don't have too many in the pod, so I don't.
All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with, what's his name? I just found it and lost it. Colfie, Collife, Montfort, Montford. And no drugs unless prescribed, no alcohol, no weapons. You can have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. Stay out of Fulton County, sir, unless you're for court or to see your lawyer. No gas, no food, no snacks, no anything like that. $20,000, $20,000. $40,000 good bond. Best of luck to you, sir. You can leave the booth. All right. Do I have, you ready, Miss Rondon, on Mr. Dem?
Yes, I do have an announcement.
Okay.
I did not actually miss this one, but Mr. Dem has a C3 lawyer. Mr. Joe Brown was appointed to his case on May 31st.
Isn't he?
Yeah, I saw that this was reset to get him a C3, so I just didn't see any entries, so I didn't know who to reach out to.
Yeah. I don't know how we can like smooth that process when it goes to C3 and the time amount. I mean, sometimes they'll tell them like in March and they don't have a C. I don't know how to make that transition more smooth or how we can get people to do it. So I guess this will have to be reset.
I think too, the C3, it's hard to enter an appearance, you know, when it's not a CP number. And if you don't do that, they get appointed, but no one knows who to notify that attorney that they're on the calendar.
Everybody needs to act like they're in civil cases. Do an entry of appearance.
Yeah, just no entry file. So
exactly,
Yeah.
There's none. He's got it. You know,
And yeah, I see that too. I looked up in Odyssey during the previous case and I don't see an entry filed, but according to our JCAT system, he was appointed on the date, the May 31st date. I can find his contact information and reach out to him and specifically let him know about this case so that he can visit with Mr. Dem if he hasn't already and appear to represent him for bond purposes.
all right.
I'll reset it. I mean, because at this point, I'll just reset it and send Mr. Brown an email, Judge.
All right. So, sir, you're stuck there with your $245,000 bond until we get your lawyer here. You can leave the booth. Thank you.
Can you give me a reset date, or is that something that'll be determined later?
I'll do June 26th.
Thank you.
All right. Thank you, Mr. Hawes. Have a good evening. I
You
got
too.
hyphen or hyphen Smith. Mr. Smith. Wave your hand for Mr. Smith. Thank you. Position 18, Bostic 22, CP 212877. 254 days without indictment. So January the 14th, there is a $40,000 good bond. Criminal attempt to commit armed robbery, aggravated assault with intent to rob, kidnapping, possession of a firearm or knife during the commission of or attempt to commit certain felonies. Pre-trial.
Only prior arrest.
All right, go ahead, Ms. Rhonda.
I apologize. Pretrial, did you say no prior arrests?
Correct.
Okay. Before you is Mr. Smith. He is 25 years old and has been in the Atlanta area for the past 4 years. He does have family here, including his mother and his sister. I will need to change his address with the clerk's office, but he does have an address in Marietta where he will be able to live with his mother. He does have his GED, and prior to being arrested, he was working at FedEx doing package handling. He had been there for approximately 6 months. Since Mr. Smith has no prior history, there's no indication that he is a risk to commit further felonies. He has not had an opportunity to miss any court dates because this is the first time he's ever gotten in trouble. He does have a $40,000 straight bond. I would ask for that to be reduced significantly. I would ask for bond to be in the amount of $20,000 and for it to be a good bond.
All right. What says the state?
Your Honor, this defendant has received a bond, and we believe it's fair and reasonable considering what has been going on, especially in the warrants, and a danger that he poses to the victim in this case. However, if Your Honor is inclined to lower the bond above the state's objection, we would ask that it be no less than $30,000 with an ankle monitor, 24-hour curfew, with the exceptions of legal, medical, and basic life necessities, no contact with the victim, and no firearms while out on bond.
All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Mustafa, Mustapha, last name Fella, Fellah. Stay away from 6300-200 Powers Ferry Road in Sandy Springs, which is in Fulton County, and you're going to stay out of Fulton County unless you're for court or to see your lawyer. No gas, no snacks, no anything. No reason to come to Fulton County at all. Court, see your lawyer. Straight to the courthouse, see your lawyer, straight home. Fill up with gas and cob. Do everything you got to do. So I'll go 7,500 on each count. Best of luck to you, sir. Get laid the boot. 7,500 on each count.
That is an ankle monitor, correct?
Yes, ma'am. Paid for by the county. Stay out of Fulton County. Court, lawyer, medical, employment. As long as you provide the name of your employer, proof of employment schedule, exact location you'll be working.
And Your Honor, that is a good bond.
Yes, ma'am.
Thank you.
We got Antonio Colbert. All right. So Ms. Rondon, on this, and Bostic, on this one, did he make this bond on? And all we have are the two things that's under pretrial?
I can double check.
Bostic, you folks came off of it?
I would say so due to the fact the defendant has a new case.
Yeah, I don't know if it says rapid bonding.
Let me look.
Let's see if I can. I hate to admit it, Bostic's much better at looking that up sometimes than me.
Not even.
While you're looking, it's 22 CP 214430, Antonio Colbert, 175 days without indictment, 7,000 split bond as of December the 5th. Possession of a firearm or knife during the commission of certain felonies, entering an auto or motor vehicle with intent to commit a theft or a felony, possession of tools for a crime, misdemeanor obstruction, and possession of a pistol or revolver by a person under 18 years of age. Rah.
His only prior arrest was the open case, 22 CP 214816.
All right. Ms. Rondon, see, I can't, did you see if they came off of it? The bonding company too?
I don't see where the bonding company came off.
Well, I tell you what we'll do is we'll just address the ones on pretrial, and I'll just go ahead in case they didn't, we won't mess with the other ones. So we'll just address 3 and 4, possession of tools for a crime and willful obstruction.
Okay. Mr. Colbert is 18 years old. He has lived in Atlanta his entire life, and he has his whole family here. Mr. Colbert was set to graduate high school in May, but his incarceration has derailed that. And I know he will have plans to finish his schooling once he is released. Prior to being arrested, in addition to being in school, he was also working at a box truck company. He had been doing that for about 6 months, and it's my understanding that he would be able to return to that employment as well as return to school. He does have a good address on file. It is the Johnson Road address where he would live with his mother and grandmother. Considering he does not have a substantial history and he is a young adult, only 18 years old, I would ask for a bond to be set very low. I understand previously it was pretrial services, and if pretrial is, I would ask for pretrial to come back on, but if pretrial is unwilling to come back on, and the alternative, I would ask for bond to be set in the amount of $500 per count.
Yes, it's just these two charges and the new entering auto that's holding him in custody.
Yeah, and I already
He
know
has 1,500 on the new entering auto.
All right, and Bostic will say no to coming back on. So, what says the
Correct.
state?
Yes, Your Honor. So, and we're only addressing positions 3 and 4.
Right, because I think he's already made those other ones. So,
Okay, so for position 3, state would be requesting 1,500. Position 4, state would be requesting 500. Same conditions from the other bond agreement to be put into place. I think it's all outlined in there.
all right, no drugs unless prescribed, no alcohol, no weapons. No further contact with your co-defendant, Elijah Simmons. No further contact with Byron Cohen, Brianna Davenport, ENA, anyone from ENA Holdings. So it's 3,500, 2,500, 1,000, 500, and 1,000. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, or school, as long as you supply the name of your employer, proof of employment schedule, the exact location you're going to be working. And if you're in school, sir, you have to supply proof of enrollment and proof that you're going. Stay away from 1350 Mason Turner Road. Stay away from 60 Andrew International Boulevard. Best of luck to you, sir.
Judge, could you repeat those bond amounts?
1,000 and 500. The other bonds are staying like they are.
Okay, thank you.
Okay.
Your Honor, I do have an announcement from another ADA on position 4, if you're inclined to hear it. Everyone wants to just leave me by myself, so I wanted to get her out as soon as I could, if you'd be permissible. Position 4, Tiffany Thornton, and then there's another attorney on it as well.
Calvin Schaff for Miss Thornton.
Oh, those are, yeah, oh, those are bond modifications. Okay, what about it?
Judge, we have a consent agreement on Miss Thornton. We can prepare that and present it to the court. Once Miss Washington, formerly known as Miss Hunter, I didn't recognize her earlier, but we can sign those and present it to the court, or we can kind of give you a quick summary of what we're doing as well. Whatever Your Honor prefers.
If you want to go real quick, you can put on the record what you're going to do, then you can send me the order.
Perfect. We can certainly do that, Judge. On Miss Tiffany Thornton, position number 4, Judge, ADA Washington, and I have agreed that Miss Thornton's current address will be changed to a Cheshire Bridge address. We will be providing that specific address to the state and then present that in the bond modification as well. Her curfew shall be from 7 p.m. to 7 a.m., allowing her to go to and from her employment, to and from her child's school, for emergencies, medical and legal appointments, for court appointments, and as well as to pick up groceries. And lastly, Judge, the ankle monitor, which Ms. Thornton pays for right now, will, from this point, once the bond modification is signed, will be sponsored by the state. That's all, Judge.
Okay, and if you put on their basic life necessities or necessities of child care or caring for her child, that's fine. Ms. Thornton, what you'll need to do though is call the ankle monitoring company and your lawyer every time you go do something. They got to know where you're at because the state gets a copy of that. Okay. All right, you guys can just email that one to me. Thank you, Ms. Thornton. Best of luck to you. Thank you, Mr. Shaw.
Thank you so much, Your Honor. Have a great evening.
You too. All right, Kaylin Giles. Kaylin Giles. Booth 4 South. Booth 3. 4 South. 4 South. Booth, shut the door. Shut the door. Shut the door. What are we doing? Shut the door. All the way. All the way. All the way. No, all the way. Bam. Slam it. Sit down. Head up. Head up. Sit up. Kaylin Giles, wave your hand. Oh, that's you, Mr. Giles. So you just gonna walk out, weren't you? Well, you can stand by a second. How about this? DeAndre Norris. We're gonna see if you can sit there and act proper for a few minutes while we handle something else. All right, it's number 16. 22 CP 212846, 254 days without indictment, possession of marijuana with intent to distribute, possession of firearm or a knife during the commission of a felony, possession of firearm by a convicted felon. I got Freedom Rings posted bond on this because there's a $19,000 good bond on this. And then there's 23 CP 217295, aggravated assault and one charge of battery. And there's a $30,000 bond on that as of 3/30. Pre-trial.
Judge, in regards to this defendant, where am I? 2 arrests for probation violation, 1 FTA, 4 felonies, 2 misdemeanors. On probation for entering auto, sentence 12622, 18 months confinement, 3 years, 6 months. Also 421 SC 1779220, firearm by convicted felon, 12622, again, 18 months confinement, 3 years probation. And then there's a theft by receiving, firearm by, firearm during, sentence in 2019, 1 year confinement, 4 years, 8 months probation. Nothing further.
All right, Ms. Rhonda, you got one of the cases, right?
Yes, I have position 16 and I saw position 17 is on the calendar, represented by Attorney Shada.
Yeah, so did Freedom Rings post his bond and come off of it?
From what I can see, it does look like he posted bond back in October, but I don't see where the surrender paperwork was filed.
Sir, do you know if they surrendered the bond? Just a thumbs up or a thumbs down? They did not, or you don't know? They didn't?
Okay.
Which is weird because it's got a $19,000 bond, but it said they posted 22.5.
Right.
I can do a couple things, Miss Patton and Miss Rondon. I can leave it as it is. And that way, if he didn't, because I'm the one that did the bond order back in January. So it has all my, the conditions I typically put on it anyway. And because that way, if I reduce it and he's made it, it may mess everything up.
Yes, I'm looking at his booking screen now. And it looks like what's holding him in is actually probation violations. Potentially not a bond surrender.
Okay, so
Judge, actually, it is both of these cases. But it appears there's already a bond on it. 12. A minute. 14.
Well, they both have bonds set on these.
It's 19.5 on the first case.
Right.
And 30 on the second case.
Right, but neither.
And then no bond on the probation violation.
Yeah, Your Honor, it's a probation matter that's holding him in. I don't believe it's the two matters.
So he's made both of these bonds?
He hasn't made them yet, but what's holding him right now is the VOP.
So Freedom Rings, he never went there?
I'll believe anyone take forfeit or anything with the bond. So no.
From what I can see, it does look like he went through Freedom Rings for position 16, which is a 22 CP case, and he has not posted bond yet for Attorney Shada's case, which is the 23 CP, and then additionally he has the 3 probation holds.
All right, is there any objection from the state just leaving 16 like it is?
Your Honor, no, but so it sounds like he's already made bond on that one. Is that what I'm hearing, that he's already gone through that company?
It sounds like it. It doesn't look like 7 North, booth 3, head up, Head up, head up, head up. If I can stay awake, you can stay awake. All right. It sounds like they may have made it, but I don't want to mess that one up if he didn't already post it. Because if I do something to it, it would really throw a wrench in everything.
Well, my argument was going to be to leave it the same, so that sounds fine to me. I don't quite understand, but I'll just make a note of that because it sounds like he's posted it with that company. And I just, while you guys are speaking, he's nodded his head several times. So I'm guessing he's gone through that company for that case.
Right. So we can address position 17 because he did not post that one. So go ahead.
Yes, Your Honor. 26-year-old, maybe you've heard this before, but he's 26 years old. He does have a child, a 2-year-old child. If he was able to get out, he does have a job lined up. His auntie owns her own cleaning company. That's Cullen's Cleaning Service. 11th grade, his highest level of education is 11th grade. I think he said a lot of the charges that he spoke about or that was spoken about him, he has completed probation on that. He would live with his girlfriend in Fulton County. That's the address he has. If there's another address, like I know the court's been given, stay away from Fulton, I can ask him if there's another address. But we would ask, I know that there's a $30,000 bond. I would ask for a lower of that to $15,000, Your Honor. Thank you for hearing me out.
All right. What says the state?
Your Honor, we would ask that the bond be left as set. This incident that occurred on position 17 did happen in the jail, and the victim in this case did receive bodily injuries by use of a handmade shank. The bond put in place is fair and reasonable. We would ask that the conditions of, which I believe are already listed, no weapons, either man-made or otherwise, and no contact as much as possible. They do mention several co-defendants in the warrants. And the victim. So no contact as much as possible. Like I said, I understand they don't control where they go, but as much as possible.
All right. No drugs unless prescribed, no alcohol, no weapons. You can have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, place of employment, schedule, and the exact location you're going to be working. No further contact with the alleged victim, Dontavius Ellis, Ellis. No further contact with your co-defendants, Eugene McWhite, Cameron Longio, Ricky Lockhart, and Otis White. 12,000 and 12,000 since I added some conditions. Best of luck to you, sir. You can leave the booth. All right, now, Mr. Giles, good job sitting there. Good job. I appreciate it. Position 7, 23 CP 216711. No bond as of March the 4th. 314 days without indictment. You got, but not on this case. Aggravated assault, this arrested date was 3/3/23. Aggravated assault, possession of a firearm or knife during the commission of or attempt to commit certain felonies, and unauthorized possession of a weapon by an inmate. Pre-trial.
9 prior arrests, convictions, first offender, 2018 on a burglary, theft by receiving and obstruction, 2018 conviction for entering auto, 2019 theft by receiving stolen property, criminal damage to property, fleeing and eluding obstruction, 2018 entering auto, 5 counts, open case, 22 CP 211179, robbery, firearm by firearm during giving false name, and theft by receiving stolen property. Nothing further.
All right, go ahead, sir.
Yes, Your Honor. Mr. Giles is 23 years old. If he was granted a bond, he would be residing at 746 Mayland Ave in Atlanta. That is in Fulton County. He'd be living with his father. He has a 1-year-old son and a 1-year-old daughter. He has a job that he believes he can return to at UPS. Given all that and the time that he spent in custody on this charge, we would ask the court to grant a bond, and we would ask the court not to set that bond any higher than $20,000.
All right, what says the state?
Yes, Your Honor. The defendant in this case is entitled to a bond as such as his right, based upon the fact that he's been in for over 90 days without indictment. That being said, state would ask that the bond be no less than $40,000 for the entirety of the case, with the conditions of no weapons, man-made or otherwise, no contact with the co-defendants, and ankle monitor paid for by the county with a 24-hour curfew, with the exceptions of legal, medical, and basic life necessities.
Hard to say all that without taking a breath, isn't
it? It is. Thank you. Thank you.
No drugs unless prescribed, no alcohol, no weapons. No further contact with the alleged victim, James Christian. No further contact with co-defendant, Kentrell, Kentrell, last name Hall. Income monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. That income monitor will be paid for by the county. And also, so I've got 20,000, 15,000, 15,000, 20,000, 15, and 15. Best of luck to you, sir. You can leave the booth.
That completes my business, Your Honor. May I be excused?
Yes, sir. Have a good
Thank
evening.
you. You too.
I'm sorry to interrupt. My business is concluded this evening as well. May I be excused?
Yes, ma'am. Absolutely. Have a good evening.
You too.
All right. Let's see. We got Stephen Harris. Thank you, sir. All right. This is position 3, Bostic 23 CP 216046. Stephen Harris, 376 days without indictment. But not this case. This case is the incident date was 2/7/2023. Interference with government property, arson in the first degree, 2 counts of reckless conduct. No bond as of March the 9th. Pre-trial.
15 prior arrests, 1 misdemeanor, 3 felonies on probation and Cobb. Cocaine, purchase, manufacture, distribution, theft by receiving, sentence 5/24/15, 1 year confinement, 9 years probation. Into the cab, aggravated assault of law enforcement officer, theft by receiving stolen property, 9, 10, 15, 2 years confinement, 8 years probation. Open case 22 CP 209542. Aggravated assault with a deadly weapon, aggravated assault 3 counts, firearm during 4 counts, firearm by street gang activity. Nothing further.
All right. Go ahead, Ms. Rondon.
Mr. Harris is 27 years old. He does have a good address now here in Georgia. The address I will have to update with the clerk's office. It is going to be located in Douglasville, Georgia, where he will be able to live with his brother. He does have the majority, nearly all of his family here in Atlanta. That includes his mom, his many siblings and extended family. They live here in Atlanta, Douglasville, and Cobb County. He is born and raised here, so Atlanta is all he knows. He did go to the 12th grade at MLK High School, and although he did not graduate, he is looking to complete his education through a GED program. Prior to being incarcerated, he was working, but he's not going to be able to return to that employment. So once he is released from custody, he's going to be looking for a new job in the Douglasville area where he's going to live. At the jail, he was a part of the Academy Hope program, but his involvement with that program has been interrupted because he has been attacked at the jail several times. Specifically, back in around December, he was stabbed 13 times, which sent him to Grady Hospital. He has been in custody on this case specifically for 125 days. He has been in custody in general for a year. He is entitled to bond on these charges, and I would ask for bond to not exceed $15,000.
All right, Ms. Patton.
Yes, Your Honor. I thank Ms. Rondon for doing the math for me because I was literally just trying to figure out if it had been 90 days since March 9th. So this defendant is entitled to a bond based upon the fact that it's been 90 days without an indictment. However, if you look at the warrant, what's alleged here is extremely concerning. Also, I know these matters are not to be considered for bond, but the fact that this defendant has subsequent gang charges is concerning as well for the community and particularly to this victim. The state will defer to the court's discretion as to the bond amount to be set. I just would ask that you take in all of accounts of everything that's in the warrant and the charges that this defendant is facing, in addition to the fact that this defendant does seem to have gang ties as well.
It looks like they alleged it was $100,000 in damage.
Can I respond, please?
Sure, go ahead.
Sure. We did have a preliminary hearing on this case. And if we're getting into the facts of the warrant and what was said at the preliminary hearing, Mr. Harris is not the individual accused of actually setting the fire. It was his next door cellmate that set his trash can on fire. And yes, alleged is $100,000 worth of damage, but when asked on the stand about that $100K figure and what assessment was done to come to that number, the deputy had no answers, could not give me any information about how that number was reached. And I'm very suspect that a fire that was put out with one fire extinguisher caused $100,000 worth of damage. Additionally, the state mentioned that his other case does involve gang charges, but we are adamantly opposed, or, we are asking that he's going to fight that case, and he already has bond set in that case. And so again, he's been deemed eligible for bond. He is entitled for bond, and I would ask for bond to be set reasonably in this case.
No drugs unless prescribed, no alcohol, no weapons, no further contact with your co-defendant, Robert Wilson. You're going to have an income monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. Stay out of Fulton County unless you're here for court or to see your lawyer. Don't stop for gas. Don't stop for snacks. Throw snacks in your car, as a matter of fact, if you have to come here and see your lawyer. All right, so we got $20,000 on each count. Best of luck to you, sir. You can leave the booth. All right, I got Jabari Porter. All right, it's position 12 and 13. Bostic 23 CP 215609. 602 days, but not this event. This event happened 1/20/2023 at the jail. Aggravated assault, disorderly conduct, false imprisonment, riot in a penal institution. And that's no bond as of January 21st. 22 CP 214965. 602 days without indictment. Not this case. This event was 12/27/2022. No bond as of 6/6. Riot in a penal institution, aggravated assault. Rah.
Two prior adult arrests has a hold in Decatur for burglary. Open case 22 SC 184855, hijacking, entering auto, 3 counts, theft by receiving, theft by taking, 3 counts. And then there's ID theft, fraud, 2 counts, signed to Judge Richardson. Nothing further.
All right, and this one says allegedly has a 25-inch metal object. Go ahead, Ms. Rondon.
Yes, Mr. Porter is 18 years old. He's a lifelong resident of Atlanta, and he does have his entire family here. Considering he has lived in Atlanta his entire life, he is not a flight risk, as he knows nowhere else, and he has his entire family and all his roots here in the area. He did go to the 10th grade at Frederick Douglass High School, but his education was interrupted by his arrest. He does have a good address. It is the Fair Street address where he would be able to live with his mother and 4 siblings. They've been in that house for approximately 5 years. As Your Honor mentioned, Mr. Porter has been in custody for 602 days. Although he has not been in 602 days on these cases specifically, that is a very, very long time for someone that is 18 years old to be in custody. On case or position 12, which is 23 CP 215609, he has been in custody for 143 days and currently has no bond. I would ask for bond to be set as follows, which is 10,000 on count 1, 5,000 on count 2, 5,000 on count 3, 5,000 on count 4. That is a total of 25,000, if my math was correct. On position 13, which is 22 CP 214965. He has been in for 167 days, and he is currently in no bond status. I would ask for bond in that case to be set at 15,000.
All right, Ms. Patton.
Yes, Your Honor. For position number 12, 23 CP 215609. There's 4 charges there. The state will defer to Your Honor's discretion. I just would like to point out that this defendant has 2 open cases that are involving the same sort of charges here. That in itself is a significant likelihood to reoffend. I understand that he has been in jail for a long time, not necessarily on these charges. However, 2 separate cases, same sort of incidences. For position number 13, 22 CP 965. Again, the state would defer to your honor's discretion on the bond amount. Again, state would just like to point out that the second open case the defendant has with the same sorts of charges, and as such, a high bond would be appropriate in both of those cases.
All right. Position 12, ending in 5609. No drugs unless prescribed, no alcohol, no weapons. No further contact with D. Roberts. That's all I have was the initial. You got to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, the exact location you're going to be working. Got 15, 5, 15, and 15. 15, 5, 15, and 15. Position 13, ending in 4965. 15 and 15, $30,000 total good bond. No drugs unless prescribed, no alcohol, no weapons. No further contact with your co-defendant, Tyrone Lindsay. Ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment. As long as you provide the proof of employment schedule, name of employer, proof of employment schedule, the exact location you're going to be working. Also, no further contact with not related to me, Cedric Manning, Manning. Best of luck to you, sir. You can leave the booth. Oh, and by the way, you're 18, so anything, Miss Jamie, anything that his mother pays out of pocket for his bond, he has to pay his mother back. Anything that his mother comes out of pocket to pay for his bond, one of his bond conditions, he has to pay his mother back. This is a you.
Okay, and Judge, one quick question. Cedric Manning, would that be a co-defendant as well?
No, that's the victim, alleged victim.
Okay, thank you.
But he has to pay his mother back. Make sure you put that in there. All right, you lay the booth, sir. Myron Nige. Myron, all right. Position 10, thank you for being patient, sir. And position 11. These are both in jail and the incarceration dates are not this exactly. So position 10, 22 CP 212606, Myron NJIE. Aggravated assault, 728 days without indictment, but not this. And there's no bond as of 9/24. Position 11 is 23 CP 217517, 728 days without indictment. This incident date was 4/6/2023. 2 counts of aggravated assault, 1 count of possession of a firearm or a knife during the commission of or attempt to commit certain felonies. Preach! Rah!
1 prior arrest, open case 21 SC 179247, armed robbery, kidnapping, aggravated assault with deadly weapon, aggravated assault, firearm during obstruction, signed to Judge Whitaker in judicial hold. Nothing further.
All right. Go ahead, Ms. Rondon.
Yes, Your Honor. As mentioned, Mr. Najee has been in custody for a significant period of time, although not particularly on these 2 cases, but he has been in custody for 728 days. Mr. Najee is 20 years old. He's currently residentially challenged, but we'll be working to set him up with an address that he could stay at once released from custody. On position 10, which is the case that ends in 2606, he has been in custody for 262 days without indictment and is currently set for no bond. I would ask for bond to be set in that case at $10,000. And on position 11, which is the case ending in 7517, he has not quite hit the 90 days on that case, but I would ask for the bond to go into effect on day 91. He's currently in no bond, and I would ask for a bond to be set not to exceed $25,000.
All right, what says the state?
Yes, Your Honor, for position number 10, that is the case number ending in 606. State would defer to Your Honor's, the court's discretion about the bond amount to be set. I believe he has reached over 90 days, so he is entitled to a bond based upon that. For case ending in position number 11, case ending in 517, again, the state would defer to the court's discretion. Just would like the court to take note of the fact that this defendant has 2 open cases, similar charges, similar incidences at the jail, and as such, we would like the court to take note of that, and we believe in a high bond would be appropriate. I think Your Honor is able to do something where the bond is set at the 91-day mark.
Yes, ma'am.
So I would request that that be instituted as well.
All right, let's see. So on position 10, ending in 2606, no drugs unless prescribed, no alcohol, no weapons, no further contact with Tedrick, Tedrick, Whitaker.
Judge. Did he just leave? Was he in 7 North?
Let's see.
Booth 6? Booth 3?
I do think he was in 7 North, booth 3.
Yeah,
He just walked out.
Well, what you want to do, Miss Rondon? I love it. This is what's hard about this. People think it's easy to control people on Zoom, but it's not. What you want to do? He doesn't really care. So sounds like that's pretty obviously that he's waiving his appearance.
Yes, I would still ask Your Honor to proceed and set bond in these cases, especially position 10, because he is entitled to the bond and it's been 262 days. Again, I would ask the same thing on position 11 and just have the order go into effect on the 91st day.
Miss Rowe, would you please place on here for Miss Rondon that he got up and left the booth before me even announcing the bonds amount?
I'm sorry, could you repeat that for me, Judge?
Could you put on this bond order that he left the booth before I got to announce the bond amounts so that you can't say Miss Rondon didn't have, I mean, he left himself, so.
And that's 10 and 11, correct?
Right. That the defendant got up and left the booth before the court got to announce the bond. All right, position 10, ending in 2606. No drugs unless prescribed, no alcohol, no weapons, no further contact with Tedrick Witters. Ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as he supplies the name of employer, place of employment, proof of employment schedule, exact location he's going to be working. He also has to supply an address where he's going to be living before they let him out of jail. $15,000 good bond. Position 11 will go into effect on that 91st day. So he was in jail 4/6. We'll just have to get the 91st day. I'm not sure. Ms. Jamie asked Dexter. We're all trying to figure out what, like, how to hold them so that they get filed on that 91st day if he's not indicted. So we hold it unless he gets indicted. So that's the one ending in 7517. Got 15, 15, and 15. No drugs unless prescribed, no alcohol, no weapons, no further contact with Dylan Bellard, Bellard. No further contact with Giovanni, Javauhny, Skrine, Skrine. Ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as he supplies the name of his employer, proof of employment schedule, exact location he's going to be working. Once again, one of his bond conditions is that he supplies an address where he's going to be living before they let him out. All right. So now we've got Kaylin Bussey. Thank you, sir, for being patient. Position 22, Miss Rockwell. Thank you, Miss Rondon, if you need to leave, unless you've got some of the bond modifications.
I do. I'm on the bond modification.
Oh, sorry.
All right,
Could
Ms.
you
Rock-
hold on
yes.
2 seconds? His mama just wants, I'm just gonna call his mama so she can listen.
Okay.
She doesn't know how to get on the this YouTube and all that. But I'm ready.
Okay. Position 22, 22 CP 206779, Kaylin Bussey. That's 479 days without indictment. And right now there is a $404,500 good bond as of March 13th, 2023. Aggravated assault, aggravated assault, aggravated assault. Possession of a firearm by a convicted felon, possession of a firearm or a knife during the commission of a felony, possession of marijuana with intent to distribute, possession of a controlled substance in Schedule 1 or 2 with intent to distribute, fleeing, attempting to elude, interference with government property, driving with suspended or revoked license, willful obstruction of law enforcement officer, felony ×3. Pre-trial.
Multi-state arrest in North Carolina, 12 in Georgia, 2 felonies, prior burglary, a misdemeanor, fugitive from justice, arrest in 2020, open case 22 CP 212, 409, unauthorized possession by an inmate. And then on probation 22 SC 183363, robbery, aggravated assault with a deadly weapon, firearm by 3 months confinement, 4 years, 9 months, probation 22223, nothing further.
All right, go ahead, Ms. Rockwell.
Judge, Madam probation, not probate, Madam pretrial. I was looking at that 23 SC 183363, and it says 5 to do 3 months, balance suspended. Do you mind just trying to take a look at the document itself? Because I don't want to misquote anything to Her Honor. For the record, Judge, he is 25 years of age, born in East Point, went to Hateville Charter and Banneker High, He is not married, but he does have a 5-year-old son. He's gonna live, if he can get out of jail, he will be living with his son's mother and the son. I spoke with his employer, Rackley's Contracting Solutions, where they do home improvement and renovations. That job awaits him. I thought he was under a suspended sentence, not probation, and he does have that open case, Judge, but that bond's a bit out of reach. So I don't know how much you're gonna be able to help me with that, Judge, but he needs a bond substantially lower than that. Obviously with conditions that the court deems appropriate.
So he's gonna live in Fayetteville?
Hold on, let me ask Mom. Mom, will he be able to live in Fayetteville?
Yes.
That's a yes, Judge.
Okay. And this is the only case that's holding him, right, at 479 days?
Yes, because that other one is a $15,000 bond, the open case.
Okay. All right. Ms. Patton, what says the state?
Yes, Your Honor, this defendant has received a bond. We believe it's fair and reasonable, and we would ask that the bond not be lowered. If Your Honor is inclined to lower the bond above the state's objection, we ask that it be no less than $350,000 in total. I just would like to point out this defendant has multiple violent charges in his history, as well as I'm looking through it now. In addition to heard out by pretrial, this is not the first time that he's been trying to get away from an officer, and this particular incident has definitely escalated, in turn making it a danger to the community at large. Nothing further.
All right, but where are we at on indictment? Because it's 479 days.
Your Honor, I have the same answer I generally have. I can submit an email. I'm happy to follow up about it, but.
And I've sent the email, like I said at the beginning, right before court, about all the cases and the number of days to give Miss Willis a heads up. All right. No drugs unless prescribed, no alcohol, no weapons. Miss Jamie, this is all on my previous bond order. No further contact with the victims. Trooper Youngblood, Trooper Brown, Sergeant Tarpley, Carpley, unless in their official capacity. No drugs unless prescribed, no alcohol, no weapons. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical meetings, employer, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. Stay out of Fulton County unless you're for court or to see your lawyer. Absolutely no other reason to come to Fulton County. Don't get gas, don't get any snacks, come straight here, go to court. Actually gonna have to get a ride because there's gonna be no driving until your bond is modified. So you're gonna have to get your mama to give you a ride. And if your mama's paying half your paying to get you out, you got to pay your mama back. Whatever she pays out of pocket to get you out on bond, you're gonna have to pay her back. All right. Let's see. Yeah. All right, since it has been, like I said, 479 days without indictment, we'll cut it down 50, 50, 50, 4, 4, 2, 4, 7, 20, 500, 7,000, 7,000, 7,000. I'll say it one more time. 50,000, 50,000, 50,000, 4,000, 4,000, 2,000, 4,000, 7,000, 20,000, $500, 7,000, 7,000, 7,000. Best of luck to you, sir.
Thank you, Judge. May I be excused?
Yes, ma'am. Good to see you, Miss Rockwell.
Thank you too, Judge. Thank you, Madam Prosecutor. I might call you to see if we can do something with this. I mean, you know.
Call me?
Yeah.
She's not gonna call me an ass. Okay.
Not me.
I'm at the bottom of the totem pole, but I'm happy to help any way I can.
Yes, ma'am.
All right. What about, is Glenn Henley here? Mr. Henley, can you turn your camera on?
Yes, ma'am.
All right. Thank you, sir. All right. Let's see. All right, Mr. Jerome, you ready? This is position 1 on the bond modification. Bostic 22 CP 210067. Glenn Henley, possession of marijuana with intent to distribute, possession of Schedule 2 controlled substance, aggravated assault, driving, fleeing, and attempting to elude, and possession of dangerous drug. Anything I need to know, Bostic?
No.
All right, go ahead, Mr. Jerome.
So, Your Honor, this is actually a motion to amend bond. This is a follow-up to our previous motion that we had to amend bond. The bond condition we're trying to amend is the ankle monitor. We're just trying to get the ankle monitor removed. He was put on the ankle monitor last year. His father passed away. He supports his mother. His mother is a small business owner and he does deliveries for her. And so we were looking to have that ankle monitor removed. And so you just essentially said, he needed additional time and put him on the calendar again.
Is that your mom sitting behind you, Mr. Henley?
Yes, ma'am.
Hey, Mom, how are you doing? All right, Miss Patton.
Hello.
All right, so I think Miss Patton, I talked with me and Judge McBurney chatted and was like, a year is plenty, if there hasn't been any violations, and Bostic says there hasn't been any violations. So what's your position?
It's the court's discretion.
Well, of course it is, but what's your position?
Well, I mean, I don't know much about it. If he's had no incidences, then it's been on for a year.
Yes.
In total. I have no objection to it.
It's okay, Miss Patton. I've been on the news before. It happens. People get like that. But it looks like Mr. Henley's mama is gonna take care of Mr. Henley.
She is. Yes. She's
right.
very attentive.
All
Well,
right.
that goes a long way then. So I feel a little bit better about it now.
Exactly. All right. So, Mr. Jerome, just shoot me an order and they can take it off. Okay.
All right. Thank you, Your Honor.
All right. Do what your mama
Thank you.
says, Mr. Henley. You got a good mama. Take care of yourself.
Thank you so much.
All right.
I will-
Thank you. All right.
Okay.
Eric Gibson. Eric Gibson, where you at?
Good morning, good afternoon, Your Honor. Nate Dobson here on behalf of Mr. Gibson. I saw him on earlier. I'm looking to see if he's still on the second page. I see 2 screens with his name on them.
All right, let's see. That's
There you-
position 2, 22 CP 209889. Reckless conduct, simple assault. Anything I need to know, Bostic?
No new arrest.
All right. Go ahead, Mr. Dobson.
Your Honor, we're back on the calendar. The same situation as the previous matter just heard by the court. Mr. Gibson has been on the ankle monitor for a year. And we were here back in March asking the court to modify it, allow him to be off the ankle monitor, and the court put us back on the calendar for a status to make sure that he wasn't having any issues in order to consider taking him off the ankle monitor.
All right, looks like it's been on a year. Miss Patton?
Underlying charge was reckless conduct and simple assault.
Yes, ma'am.
No incidences, no objection.
All right. Just shoot me an order, Mr. Dobson. And Miss Patton, don't worry. If something goes, it comes back to me anyway. Never comes back to you guys. So, all right, Mr. Gibson. Keep doing the right thing, okay?
Yes, Your Honor.
All right, have a good day. And once he gets me the order, I'll sign it, and then you'll just get with the ankle monitor company and they'll take it off.
Your Honor, that concludes my business with the court. May I be excused?
Yes, sir. Thank you. All right, we've got Sade Bagneries. Sorry, Sade.
Hey, Judge, how you doing? Alex Arca for Sade Bagneries.
All right, let's see. Get your client turn the camera on. All right, it's 23 CP 217236. Sade Bagneries got cruelty in the first, cruelty in the third, and battery.
Correct, Judge.
Well,
Judge, I did not represent her at the first appearance. I got brought on afterwards, but I'll be quick and to the point. Judge, apparently one of the victims in the case, as listed on the bond orders, Malik Robinson, whom my client does not know, but more importantly, the second victim, Lawrence Gunn, is her son. According to the bond conditions, she's not supposed to have any contact with Malik and her son. The only problem is Mr. Gunn is her son, whom she takes care of. So again, Judge, I was not there at the first appearance, but it's kind of hard for her not to have contact with her son since she's the primary caretaker. Number two, Judge, she's 36 years old. She has no criminal history. She has 4 kids. One's a 2-month-old, which I believe she's holding there. Another one's 4. The other one's 15 years old. The other one is 16. Judge, I think it's been about 90 days since the date of arrest, give or take a day in either direction. But I was inquiring as to, one, if she can have contact with her son, because I think that might have been an error to have no contact with her own son. And then 2, if the ankle monitor can be removed. She has no prior criminal history, no prior FTAs. She lives outside of the county now, I believe in Suwannee. So she is local. Again, she's not a flight risk. I don't know why that was added on, but it just seems kind of odd considering she's a local individual with no prior criminal history, no prior FTAs.
So hold on. So she said she doesn't know Malik?
She doesn't know Malik. Apparently Malik and her son had it out. Her son was being bullied by Malik.
At the bus stop.
She went to go ahead and defend her son because her son was being jumped, is my understanding. And then at that point, she went ahead and intervened. Again, Malik is not her son. She does not know who Malik Robinson is. However, Lawrence Gunn is her son. And part of the bond conditions was that she was supposed to have no contact with him, with her own son, which.
So this says that allegedly hit him in the back of the head and pepper sprayed him into his eyes, nose, and mouth. But she's only had this ankle monitor on for how long? Since
About
March?
90 days, Judge.
All right, Ms. Patton?
Yeah, no FTAs, Judge. I mean,
I'm sorry, I didn't mean to cut you off.
Yeah, I know, this
Oh,
isn't
no,
what
that's okay.
I did, so I can't speak if it was a mistake or.
I would object to removing the ankle monitor. However, I did take a look at the warrant in terms of contact with her son. It doesn't seem like she's had any issues with her son. So just so no long as there's, no violent contact with her son, not that I'm alleging that she's done that in the past, I just would have that as a condition. But based upon what's happened with the pepper spray in the eyes and choking and striking in the back of the head, I would object to removing the ankle monitor.
All right,
Judge,
so-
I have to beg to differ. For the purpose of an ankle monitor, she usually go and track somebody's movement. And she does not live anywhere close to the alleged incident anymore. She's over in Suwannee. My understanding is that this happened somewhere in Fulton County. But if she had FTAs or something of that sort, Judge, I would completely understand. And I would always have to agree with the state. But in this situation, there's no FTA. She's got no prior criminal history. She's been doing well for the past 90 days. Furthermore, she works as a bartender and a host event consultant and does host eventing or event hosting. Sorry if I got it backwards. So the ankle monitor kind of prohibits her from doing her job because no one really wants a bartender that's got an ankle monitor just bulging out. But again, if I had heard something as to an FTA or prior criminal history, I would completely agree and understand. However, I think that's far from the issue here.
Well, I tell you what, I'm not going to make it weird a year, but I will remove Lawrence as far as no contact. I mean, like I said, I don't know. Typically, if I put they can't have contact with the child, it's like if there's a juvenile court case pending and I'll let juvenile court order, control whoever does that. But if you come back in a few months and there's absolutely no violations, I'll be glad to take it off. And, let's see, what's this?
All right.
Back in September, we'll talk about removing it then.
Your Honor, if I may, you could switch it to a teletrax monitor if she's worried about it being in place at work. I do understand that might be an issue. However, like I said, it is to track what her movements are and to ensure that there is no contact. But a teletrax monitor might be easier if she's working to pass off. Is just, it looks more like a Apple Watch.
The watch, yeah. Ms. Lewis, did they work out the issues with that?
Unfortunately, Judge, same update as last week when you asked.
Yeah, see, they haven't worked out the issues with that. So unless she wants to pay for it, because there's contract issues, whether the contract's going to cover that.
Yeah, it's beyond the pale of what we can even do or determine, Judge. We can't move the needle on any of this. This is kind of above us.
Well, I think that right there was probably Lawrence sticking his head in. Hello, Lawrence. She can have contact with Lawrence. Just shoot me the order, Mr. Arco. We'll sign it and get it back to you. And like I said, just put it back on, come back 3 weeks and we'll talk about it.
Understood, Judge. Thank you so much for your time.
All right, thank you.
Judge, you said 3 weeks or 3
I meant
months?
3 months. 3 months, sorry.
That's what I figured you meant.
Yeah, sorry. All
Yeah, I
right.
figured 3
but-
weeks would be too soon.
Yeah, but just send that to me to remove Lawrence from the order. We'll get that signed off on.
Thank you, Judge. And who should I send the order to? You directly or to your chambers?
Sure, you can send it to me directly or Miss Robinson to the, what's the email? Is it Orca?
He should have the email from where he got the notice for today's hearing from me.
Oh, yeah, just send it there. Yeah, she'll get it to me, and I'm pretty good about signing them as just quick as I get them.
Thank you, Judge. I appreciate it. And have a great night.
All right, thank you. You too. Thank you, ma'am. Best of luck to you. What about Victor Chisholm?
Good evening, Judge Ross Gordon here on that case. How are you?
I'm doing well. Let's get Mr. Chisholm to turn his camera on here.
I will see if he can, Judge. He's been having serious technical issues.
There he is.
He got it
All
on.
right.
All right.
This is 5 on this calendar. Bostic 22 CP 214707. Aggravated assault. Victor Chisholm. Anything?
No, Judge, no new arrest.
All right. Go ahead, Mr. Gordon.
Yes, Judge, we're here just for a motion to modify his bond. He's on an ankle monitor that requires him to stay outside of Fulton County, but the job that he had prior to being arrested, he worked as a mover for a moving company, and they graciously held his job open while he was in custody until he was released, and they've accepted him back in that employment. The problem is a lot of the jobs require either one of the locations either being in Fulton County or driving through Fulton County to get to wherever they're going without obviously having to charge people extra for having to drive around. So all that we're asking is that his bond be modified to allow him to enter Fulton County solely for legitimate work purposes. Obviously, I know he may have to provide, the addresses of where he's going to go and things like that before he goes there. But like a large portion of the moves, he's recently had to abstain from participating in, and his company can't really justify keeping him on with these conditions. So that's all that we're asking for today.
All right, Ms. Patton, he can come into Fulton County for strictly for work.
No objection to the work exception.
All right, just add, you can add employment, but sir, when you come into Fulton County for work, you do need to let the ankle monitor company know that you're coming here and your lawyer. Just shoot me that order and we'll sign it, Mr. Gordon.
Yes, Judge. Thank you very much. That's all I have. May we be excused?
Yes, sir. And you can put it's effective today. So if they want him to come to Fulton tomorrow, if it takes you a little bit to get me the order, it's at least it's effective today.
Thank you, Judge.
All right. Have a good evening. Good luck, Mr. Chisholm.
Have a wonderful evening.
Thank you, you too. All right. Is it Tamika Ali? All right, this is position 6. Tamika Ali, start your camera. We got 22 CP 214957. Cruelty in the first and simple battery. Go ahead, Ms. Rondon.
Yes, Your Honor. We're here for a bond modification. As part of her bond order in December of 2022, she was ordered to stay away from the family home and to have no contact with the alleged victim. We're asking for both of those conditions to be modified. Recently, Miss Ollie has been diagnosed with cervical cancer and has started treatment for that. And part of that treatment has included major surgery. It's being unable to live in her own home has caused her major issues with recovering from this major surgery and taking care of her health. She's had to live out of her car due to this bond condition. And, obviously her health is very important. And so we are asking for one, the stay away order to be amended and also for the no contact order to be taken away. It is my understanding after talking to Miss Ollie, and I believe some other folks are on the Zoom that can speak to this, that there was a defects case that was opened up in addition or, related to this incident. And it's my understanding that that defects case has been closed. And that it has been closed because the allegations from the child, she admitted she made them up. I was told DFACS was going to be on here to speak to that, and that the child herself is also on the Zoom call. So I can turn it over to the DFACS representative, whoever they are. I'm not sure which screen it is, to speak to that.
Is anyone from DFACS here? No one from DFACS. What do you know, Bostic? Anything I need to know?
Okay.
No new information, no new arrests. I think this is her only, actually.
All right, Miss Patton, let me pull it up and look at it. Anything you want to say yet, Miss Patton? Or you
Your Honor, honestly, I haven't heard anything from DFACS. If Your Honor is inclined, I would like to hear from the minor child. My position right now is objecting it based upon what's alleged. These are serious allegations. I am sympathetic to Ms. Ollie's diagnosis, but these are very serious allegations, and my position is to object. If Your Honor is inclined, I think she is on here, Sanaya.
All right, Sanaya. How old are you, Sanaya?
16.
All right, can you turn your camera on for me? All right, if you could raise your right hand, Sanaya, do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth? Yeah. All right, you got to speak louder and be still. Sit down somewhere and be still, okay? Got to see your face. Okay. Go ahead, Miss Rondon.
Hi, Miss Ollie. I'm just gonna ask you a couple questions. Regarding the incident that happened in December of 2022, well, will you tell the court whether or not you have stated to DFACS that this incident did not actually occur?
It's you, Sanaya. She's asking you a question.
Yeah, Miss Sanaya Ollie, did you hear my question?
No, can you repeat it?
Of course.
Okay, Miss Sanaya, if you're close to somebody, you need to get away because there's feedback.
Mm-hmm.
Is the defendant currently in the same?
Whoa. Are y'all at the same house?
That's what it looks like.
Sure does.
Yeah.
So right now, what you're telling me is you're violating your own bond conditions before I say you can amend them.
I had no choice. I've been reading.
Stop talking. Stop talking.
Miss
Stop talking.
Ollie.
Stop talking.
A child.
Miss
Ollie,
stop
talking.
talking.
Miss Ollie, stop talking. Absolutely nothing you say is going to help you right now. Miss Patton.
Your Honor, based upon that, my original, I would object. I think it still stands. She hadn't even stayed with the conditions as are right now. She's in the home with her. And how can the child and the victim in question be safe enough to tell me what's really going on if she's in the house with her?
And Ms. Ronna, this is not me doubting you. I can feel my blood pressure going up. Wait a minute.
I agree, Your Honor.
Miss Ollie, I am sorry for your condition. However, I am not sorry that you couldn't follow instructions. I mean, and the nerve to show, it's like, what in the world? You didn't even try to hide it.
You and lied to you.
No,
Miss Ollie.
absolutely nothing you can say. Miss
Try to have a
Rhonda does not want you to
Miss
say
Ollie.
a word. It is not going to help you. So, Miss Rhonda, I tell you what, you can place this back on another time. I'll give you a chance to have a conversation with Miss Ollie. And then put it back on for another motions hearing. But
Thank you, Your Honor, I do appreciate that chance. In addition, I know it's not changing anything today, but I was told there are documents supporting the dismissal of the DFACS case and other things that were also allegedly turned over to the DA's office.
Sure.
Since this case was not originally mine, I did not have a chance to get my hands on those documents before tonight's hearing. I will get those documents before we come back, and I will share them with the state in advance.
so, Ms. Travoria, what do you think the reset date will be for her?
It'll be sometime the end of July.
Is that okay, Ms. Rondon? Or of course, if you send stuff to Ms. Patton and y'all come up with a consent, that's fine too. I mean, just let me know.
Ms. Rondon, and excuse me, Your Honor, for interrupting you. I know you said a defects case was closed, but I'm concerned that a defects case was closed with the thought that she wasn't living there, and clearly she is. So I'm concerned that a defects case was even closed out based upon the information that we've learned here today, because it doesn't seem like it was closed out based upon all the information being given, being truthful.
I have
I'm
the
sure Ms.
number.
Rondon will get to the bottom of it.
I will get to the bottom of it. I do have a name and number of the defects caseworker. So they will be my first call. And I will.
Thank you, Ms. Rondon.
Yes.
Yeah, and if you want to send that to us, you can.
Absolutely.
All right. Best of luck to you, Miss Ollie. Have a good evening. But you need to leave where you're at. All right. Let's see. Roderick Wimby. All right. This is the last one. Bostic 23 CP 215182. Cruelty in the first. Anything?
No, Judge.
All right. Go ahead, Miss Rondon.
This is also a motion to modify bond. Mr. Wimby has a consent bond currently. The state and I were able to agree on a $20,000 bond. And at the time, we agreed to the following conditions. Stay away from Miss Nikithia Jones, Miss Linda Jones, and AW, the minor involved in this case. And must reside at the address of record, which is 120 Hartwell Road, apartment C, which is the address of his mother. My motion specifically mentioned the no contact provision with AW. In this case, there is a defects case pending. The child is currently in CPS custody, and I have spoken to the defects caseworker, Miss Austin. There is currently supervised visitation as part of the defects plan, and the current no contact order is interfering with the supervised visitation plan. And so I'm asking for the no contact order to be amended, not to have, free supervision or for the child to live with Mr. Wimby, but for Mr. Wimby to have contact with AW in compliance with the defects plan. And that defects plan calls for supervised visitation. What is not in my motion that I was just made aware of is that second condition I mentioned, the must reside at address of record, which is 120 Hartwell Road. That is his mother's home address. Mr. Wimby has found or would like to move to a new address. That address is 310 Skipper Place Northwest in Atlanta. I can provide the specific townhome number in the chat or, through whatever order I draft for your honor. He is planning to live there with his brother, his twin brother, Broderick Wimby. And so I would ask additionally if that condition can be amended so that he is allowed to move to the new location.
Which one of the, so Broderick, because who is, sorry, your name's not Twin. Are you Broderick?
Yes, the individual you were looking at with glasses, that is Roderick Wimby, and his twin is Broderick.
All right. So that is to just comply with the defects, whatever conditions defects puts in place, right?
Yes.
Patton?
No objection to complying with defects. I think it was supervised visitation.
Yes, it's supervised visitation with a defects caseworker present.
Yeah. So we'll let the defects that control any kind of visits or anything like that. Yes, he can move to 310 Skipper Place.
Great. Oh, and it just, I'm sorry, it occurred to me and I should have included it in my original argument, is the other no contact, Miss Nikithia Jones, that is the mother of the child. And I believe she will also be present at these supervised visits. She's also a no contact. So I would just ask for that to be amended so that at these supervised visits, he is not violating his bond conditions by being in the same room as her. So again, I'm not asking for them to be talking on a regular basis, but to only have contact at these DFACS supervised visitations.
Ms. Patton, I mean, that, I don't have a problem with that, so at least he can comply with the reunification plan.
Just no further violent contact. Yes, I agree.
Right, as it goes to complying with the DFACS reunification plan. That's fine too, Ms. Rondon.
All
Was
right.
it- and was there just the two people or was there the three?
The third person is Miss Linda Jones, who is Miss Nikithia Jones' mother. We are fine keeping that a no contact.
Okay, all right. I didn't know if she was part of the, like, is she the one that has the placement of the child?
Not
Mr.
that I'm
Wemby?
aware of,
Can
but
can you take yourself off mute? Is placement of the child with grandma? Or or is the child still with mom?
Oh, yes.
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 Which
It's-
one?
Oh, it's with grandma.
Okay, so Ms. Ronna, just change that to obviously contact with the grandma as it pertains to the DFACS reunification, because grandma may be there when she drops off the kid and they may pass each other. So yeah, you can do that, because once you said that, I thought maybe placement was with the child. So you can have contact with grandma only because she'll probably transport the child to wherever you're going to see her. Okay.
Okay.
All right. Yeah, just shoot me the order, Miss Rondon.
will do, Your Honor.
All right, thank you. And I think that's it. Besides, thank you, sir. Best of luck to you, Mr. Wemby.
All right. Appreciate it. Very, very professional, by the way.
Yes, sir. Thank you. All right, let's see. All right, Renee Rockwell's back. My goodness. Thank you, Miss Rondon. And Mr. Warrior.
Use either lane to turn right on Pleasant
Yes,
Hill.
Judge.
Listen, Miss Rockwell, stop driving. I'm gonna have to Miss Robinson. So Miss Rondon will be the only conflict defender for the month of July. So I told her she could email like Miss Lewis or you or Miss Watts if by chance something where she needs a little bit of a, like don't put like an entire calendar that's Mr. Olaf or all the conflict, because the whole calendar would be hers. So if she needs a little break, I told her to email you guys because she'll be it.
Right, I understand. I think for most of July, though, she probably only has one or two for the evening that I haven't done. I think most of them are out for
All right,
July.
so we're not going to run you too ragged, Miss Rondon. But if there's an issue or something comes up, please feel free, email us and let us know. Okay.
I will. Thank you, Your Honor, and I'll do my best to be present on everything that I can.
I'm sure you will, and we'll do what we can to help you.
I appreciate that.
All right. Have a good evening.
You as well.
All right. Go ahead, Miss Rockwell.
No, I just wanted to know if Mr. Khalif Montford got a bond. His daddy called me, and I thought I heard while I was waiting, y'all mention that name.
No, he did. Let's see. Wait a minute. Wait a minute. Was he on here, or was he one of the people to not getting no contact with Khalif? Oh, that was a no contact with Khalif Mumford. He was an alleged victim in a Agasaw or riot incident at the jail.
Okay, I just heard that name, so it made me kind of curious. Thank you so much, Judge, and thank you for.
And if you look, I think I sent those orders to.
Yes, I'll be sending those. I have them now. I'm sending them all out today.
Yeah.
Thank you so much, Ms. Robbins.
Thank you, Ms. Rockwell. Anything else from anybody?
Did I have questions when people get off the Zoom?
All right,
Well,
Ms. Jamie. Go ahead.
I do. So I'm just holding, for clarity, I'm holding positions 8, 11, 12, and 13, correct?
Okay, I don't know what you mean by hold them. Hold on.
I was unclear about those
okay, so
days.
all right, stand by. All right, so let's see. Larry Marshall, you have to hold that till the 91st day. That's position 8.
Okay.
It's the 87th day today.
Right.
Let's see.
And 10 was 262 days. I know it was something about these events occurred at the jail, the ones that are on the calendar today. Would those be held as well?
Wait, hold on a second. 1 second, let's see. Was it 17? 17 has to be held to the 91st day. Is that what you said? Was it 17? Right?
Let me see.
Wait. Which numbers do you have?
The numbers that I have was 8, 12, 13, and 11.
Okay, hold on. Sorry. All right. So. Twelve is fine because that event happened in January.
Okay.
No, and 12 and 13 are good because those all happened in that one happened in January, one happened in December.
Because I know you said 602 days. That's how long they've been in custody. Is that
right? But the event happened in January.
Okay, but you still want me to have a bond order to reflect the 602 days?
That's fine.
Okay.
Yeah. Let's see. But let's see. So hold 8 until the 91st day. And number 11, make sure that's the 91st day.
Okay.
Yeah, because on number 11, the event happened on 4/6. So it'll go into effect on the 91st day.
Okay, so 8 and 11. Okay, and one more question, Judge.
Okay.
Gilliam, did he get an ankle monitor?
No.
Okay. All right, I'm gonna start putting things in the queue in just a minute.
Okay, you can just text me when it's all done.
Okay.
Anything? Thank you, LT. Anything else, Ms. Robinson, or we can stop the stream?
You're welcome. Good night, everyone.
Thank you.
Good night.
Good night. All right, Ms. Patton, you gonna be there in the morning?